Welcome back. Well, with the uncertainty over evictions here in the Valley, we are continuing to answer your biggest questions. And one of the questions that a lot of you have is what happens if you get an eviction notice on your door? And Aaron, why is it so important that you answer that eviction notice?
Look, the absolute worst thing a tenant can do is do nothing. A tenant must file an answer with the court when receiving an eviction notice. Typically, that notice period is 7 days. They only have a short 7 days to file an answer with the court. If they don't file an answer, they can get evicted without a hearing within a short 7-day period. So that's why it's so important for these tenants to file an answer with the court as soon as they get an eviction notice. Now, we've made filing an answer with the court much easier. A tenant can now contact the Legal Aid Center of Southern Nevada, and we can assist them over the phone through the new online guide and file program. So we can assist them with the tenant answers if a tenant receives an eviction notice. They can also go to the Civil Law Self-Help Center, and we have a team of law clerks and eviction staff that can help the tenants complete their answers. So if tenants have any difficulty understanding the court documents or the system, they're welcome to contact Legal Aid Center or go to the Civil Law Self-Help Center and receive assistance filing that tenant answer so they can invoke their protections of Assembly Bill 486 and then the CDC eviction moratorium.
And Judge Saragosa, in between the tenants and the landlords, there's mediation. How is that going, and what kind of insight can you give us right now?
Well, all the cases that request mediation are getting sent to mediation. They're either in one of two places, either up to Home Mains, Nevada, the state-run entity, or they're going to our Neighborhood Justice Center, which is part of the Las Vegas Justice Court. So if people are requesting mediation, we're trying to push in that direction. And in echoing what Aaron said, yes, we have worked very hard. We've opened up some additional window spaces and authorized Civil Law Self-Help Center to take those over to help people electronically file their answers. All answers can be electronically filed. That's been streamlined last fall with the guide and file program. It's kind of like a question and answer interview, and it helps fill out the forms for the tenant. But the other thing that I would say is apply for rental assistance. I mean, really, at the end of the day, you can't avail yourself as a tenant of any of the protections of Assembly Bill 486 unless you apply for rental assistance. That's what triggers the stay and the affirmative defense that was put in place by the legislature. Additionally, there's a built-in part of that bill that requires the landlord to accept it. So it's very costly for a landlord to hire a process server, to get eviction notices served, to file the filing fee with the court. And what for what end? If the only end is there's rental assistance application pending and their case is going to be halted and then eventually granted and given the money, they're never going to end up with an eviction. And I would just add one other thing. While there may be a concern over the number of evictions, we're not actually seeing that in court. Our numbers for evictions for the month of June and the month of July fell within the normal range of what we see even outside of a pandemic. We typically see 30,000 evictions a year, between 2,500 and 3,000, and that's what we saw in both June and July in terms of complaints filed.
Just real quick, Judge, are you concerned about the court system being overwhelmed at some point?
That time will tell. It's hard to say what people believe about how the CDC moratorium works and doesn't work. It actually doesn't prevent the case from coming through the system. It just prevents the lockout from happening. So all along, we've processed cases in both June and July because of that. So, and it also requires the tenant to invoke that protection. So we see a lot of cases where tenants have not done that. It's hard to say. We're prepared for it, but I don't believe the court will be inundated or overwhelmed. We're ready for it if it surges.
And isn't part of AB 486 sealing the eviction records and sealing the documents so in the future that doesn't show up on their credit? And the question would be, how do we move forward? How do you know that you're renting in the future to somebody that's paying their bills? I know that's a question a lot of real estate agents have asked.
That was Assembly Bill 141, a different bill, but yes, in the same legislative session. We've already sealed about 4,997 cases. We're still working through that process to make sure that they are sealed. It seals cases that were based upon non-payment of rent during the governor's declared state of emergency. So going back to March 12th of 2020 and continuing to today and until that declaration is terminated.
All right, Judge, thank you. We'll be right back. And welcome back. You've been watching our eviction uncertainty panel.
That's right. So right now we invite everybody to give their final thoughts. I know a lot of us have lived here in Southern Nevada for a long time. We've seen the downturn of the housing market, and now we have COVID. Is there a light at the end of the tunnel? Do you have any thoughts about that? I'll start with you, Judge.
Well, I certainly hope there's light at the end of the tunnel. It's been a very difficult time, I think, for everyone. We see it in the court. We see the landlords that are struggling, the tenants that are struggling with the constant changes that have taken place in the last year between varying governors' directives, federal moratoriums, new legislation. It's been quite a challenge to stay on top of everything. We're doing the best we can, and I hope that we can continue to serve our community and get through this with the evictions that are coming.
Okay, we're going to try and hear from everyone on this. We got about 2 minutes left, panel. Who wants to go next? The same question.
And then 67% of our residents are not cooperating. They're not communicating, and they're actually refusing to apply for rent assistance. So if there's any way that we can improve transparency between CHAPS and the court system so the court knows what the status of an application is, that would actually be wonderful. And then, of course, not protecting those that continue to refuse to apply for rent assistance or invoke their protections would certainly be disappointing.
Kayla?
And that, yes, so that's something that we've been having a problem in the system as well, is if tenants don't apply, if they don't file an answer with the courts, there's really no way for landlords to know if this tenant applied for rental assistance at all. So that is actually a problem that we've been experiencing over here in regards to landlords. So if there was a way, like what Ms. Vasquez was saying, that the courts and CHAPS can kind of get together so we can see whether or not the tenant has a pending rental application, that would actually be really, really helpful. And it would be really cost efficient because someone wouldn't have to pay someone like us to do the paperwork for them, or for them to even go down to the courts and do it themselves, knowing that if they get a hearing, it's not going to happen. They're not going to get that eviction that they seek.
That's a good point.
Yeah.
And Aaron, you got the final word. We got about a minute left here.
Sure. So I have 4 closing tips to tenants. First, you heard across our panel that a tenant needs to apply for CHAP. Look, CHAP can pay up to 12 months of back rent on behalf of the tenant directly to the landlord. It's also the defense under Assembly Bill 486. So a tenant that's behind on the rent who was impacted by COVID should absolutely apply for rental assistance through the Clark County Housing Assistance Program. Second, if a tenant receives a eviction notice, they absolutely need to file with the court. That's how they tell the judge in the court that they have defenses and that they've applied for CHAP and they can have their applications streamlined. Third, tenants should enroll in mediation. It's a free process. It brings the parties together and also gives the tenants an update on the CHAP application. Finally, we're encouraging all of the tenants to get legal assistance. They can always contact Legal Aid Center of Southern Nevada or go to the Civil Law Self-Help Center for assistance. We don't charge for our services. It's all free. We're trying to help all the disadvantaged tenants in Nevada.
All right. Thank you so much for your time. We've appreciated it. We love your input. We'll be calling on you again. That's it for us. Inside Edition is next.
All right. Take care, everyone. See you back here tonight at 11 o'clock.